Am I live? Can you see me? Can you hear me? I've been talking to myself for the last few minutes thinking I was live, and I was live. I bet you there's a second. Hold on, I don't see this going live. I'm waiting. I'm waiting for YouTube to press. There we myself for the last few minutes thinking I was live, and I was live. There we go. There's a second. All right. Shh. Hold on, I don't. Oh, we're live. We went live on YouTube. Isn't that crazy? We're live. Okay. It won't crash today because that's how chat is going to be. This is it. This is me finished with chat. Now, if there's a court thing happening in that bottom corner, I'll move it a little bit. But that's where chat's going to be from now on. Now, the next thing I want to do is figure out a way to get one chat specifically bigger on the screen. I know how to do it. I just have to do it. I just spent all my time doing this. Once I get that done, then I'll install the software so I can start streaming on Twitch and other places. It's a different. I'm gonna kill this boy. I can't. We love our children, so we can't take him out back and old yeller him. We just can't. We're not allowed. So, you know, he's just gonna be screaming in the background. All right, all right. This is good. And then I'll get Twitch once I download that next piece of software. Rome wasn't built in a day. One thing at a time. We're getting there. Now, yesterday we crashed hard because I was trying to make chat bigger and it crashed. So this is approximately where we left off, but we are going to rehear a couple minutes, like a minute or two, just to be sure we're caught up. I need a cone of silence for him. I do. I need that. The boy never, ever, ever shuts up. Look, I'll mute him though. Here we go.
Where the metal stuff is. And yes, it's me at Black Sky, but this was the metal market. That was a month before. I just posted the video that I made that day on the next month.
What is the caption for this particular post?
Want to find your friends? Use the turkey call.
And this was advertising a market that day, but the video was not shot from that market?
It rarely ever is. Otherwise, I would be sitting there for 2 hours during the market making a video posting about it.
At this point, Judge, we still would move to admit N. We believe that the issues of foundation are issues of weight, not admissibility.
Objection under 401, 403, and 901.
Testimony fails to establish relevance to the dates relevant to the events of this trial, and is not admitted.
One moment. If I may approach with what's been marked as for identification as defense O. Now, Ms. Crowell, what is this?
It's a photo of me at the metal market before I got injured.
What is
Then.
the date on this post?
October 29th, 24.
It's not going to be like this one, JLo, because I made this one myself. But all my shirts and everything I have are at that link, which is, the link is really confusing. You have to pick your design first, and then you can pick the product. So when you go to that link, there's like Proud Viber, just a regular logo, Spanked with Jail Time. So you just have to pick which one you like the most, and then click it, and then it'll. Actually, I can't show you. I can't. Anyway, then you shop all products, and then you can see what they have. I know it's confusing. I don't know why they made it so badly confusing.
And what does the post depict?
It depicts me on the day that I worked the metal market, but it's not posted on the day I was there.
You said when we reviewed the last exhibit that was dated October 28th, that there was a metal market on October 28th. You just weren't at it.
Yes. Again, most of the photos that you see aren't getting posted until like a month afterwards. She has to edit them and do things.
And I'm just going to go ahead and bring up again what's been marked for identification purposes as defense N.
Same outfit because it was the same day.
So those two photos were taken from the same day,
Right.
and they are taken from the metal market.
Yeah.
Yep, it's the defense attorney making her voice sound more normal. I mean the prosecution.
One
need
is from
coffee.
your personal social media account and is dated October 28th, 2024.
Right. I'm confused by what you're trying to ask me.
And one is posted from the Metal Maidens account and is dated the next day, October 29th,
Because that's not a
2024.
question. That's why you're confused. It's a
You are
statement.
wearing the same outfit in each. Are you saying that both your account and the Metal Maidens account
I mean, it,
posted old videos of an old metal market, even though there was a metal market on October 28th?
yes. That's social media.
I would move to admit O. I would also renew moving to admit N, I believe.
All right, folks, we're going to take a break. Ma'am, I'm going to let you step down from the witness stand and ask you to wait out in the hallway. Folks, you do not have all the facts. You do not have the evidence. Do not do any type of research. Don't discuss the case. This will only be like 5 minutes. All rise. Jury's in recess.
Uh-oh. I think the lawyer's in trouble, but I don't know. Maybe we're really just taking a break.
All right, everyone can be seated. Look, to be admissible evidence by preponderance of the evidence, a proponent has to establish that an exhibit is, well, let's move backwards. It's authentic, it's relevant, and it doesn't violate 403. I don't have 403 issues here, although there aren't authenticity issues. The issue is relevance. The testimony that we have, I'll note that the defense is not trying to move these into evidence through anybody from Metal Maidens. They're not trying to move it in to evidence through any other person who's depicted in the photograph who would purportedly say that this was October 28th or 29th. The testimony from this witness is that these photographs are older and that they are recycled.
At this
And they
point,
don't depict events that are occurring on October. I presume your argument is that this is October 28th. I don't even know that we have testimony as to when Metal Market actually occurred. Well, maybe at the end you asked Metal Market happened on the 28th. Is that what I understand?
Ms. Crowell stated that a metal market happened on the 28th, but both of these photos posted from different accounts were not from that particular metal market, even though she's wearing the same outfit. I would ask the court to take judicial notice. I'm on metalmaidens.org, and I will happily print out their calendar once my
I'm not taking judicial notice of the rule requires you to provide me with that which you want me to take judicial notice of. Furthermore, and you haven't. Furthermore, you take judicial notice of something that does not, cannot.
I believe it would be well within this court's purview to take
I'm sorry,
judicial.
counsel, I'm in the middle of generally known within the jurisdiction of the trial court or capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. I am not going to take judicial notice of a calendar posted on a website, even if I were actually provided with the information.
Now we know. If you try to talk when he is mid-ponder, you're not going to be allowed to.
All right.
If I may finish my record, I understand the court's ruling, but I do just want to make a clear record.
On judicial notice or in admissibility? Because I'm not done yet on admissibility.
On the judicial notice piece, I think that it would be well within this court's purview to take judicial notice of an event that happened in Denver. If I were to provide from the official website the calendar and date of that event, especially if the prosecution were not objecting.
I disagree. I think your reading of the case law is, of the rule of evidence is inaccurate. I can't even take judicial notice of the fact that my own minute order were to say someone failed to appear. I cannot take judicial notice of a failure to appear just because it's in a court's minute order. That is not the type of fact that a court can is properly judicially noticed. And this is we're not going there. I'm not taking judicial notice of a calendar posted on a website.
As to
The
the
testimony has been that the metal market did happen on the 28th. The testimony, as I piece it together, is she sends things to, what's the name of the organization?
Metal Maidens.
Metal Maidens. Presumably they just upload what she sends. Prosecution's objection is relevance in 403. I really don't see the 403 argument. I think it really does come down to relevance.
Not only is it relevant of her weight bearing during the time that she says her hardware was broken, it's now relevant to her credibility. There are two separate accounts that posted a photo of Miss Crowell in the same outfit.
You keep interrupting me.
I'm sorry.
Kit Kat tried to warn you, but you didn't listen.
Her statement is that the nature of her testimony was that the nature of social media is that you will often post old things. I'm a little bothered by this because, I mean, good Lord, if we wanted to find somebody who would say that she was walking, my guess is there's probably better evidence. But in this situation, I will admit N and O. I will find it by a preponderance of the evidence that it is not unusual, at least in my experience, that people would post to Instagram or such things that are actually happening when they're happening. So I will admit
The pounder
N and
mouth.
O. And the jury can make of it as they will. Do we have any other videos or photos that we should be dealing with?
We do. I can play the next one now.
What is it?
It's an Instagram video from October 30th of Miss Crowell recording her dog and then recording her bare feet stomping on the ground.
Let's see it.
If I could have counsel table.
No audio.
There is, I didn't plug it in immediately.
Hey, Harley. Yeah. I taught my dog to smile. I taught my dog to smile. Harley, smile. My God. You did it. You did it. You're so good.
All right, objections from the prosecution?
I think foundation needs to be laid before I know if I have an objection, so I know when this was taken and when it was posted. I can't even see when it was posted.
Sorry, that's because it's this.
Huh?
Do full screen.
That is full screen. Here, let's do, I've been doing this Windows Media Player. DHL.
Your microphone on?
I think she shows her at a Billie Eilish concert soon, and I'm going to have to mute that right away.
Hey, Harley. Yeah. I taught my dog to smile. I taught my dog to smile. Harley.
It doesn't have the bar in front of it. You can see that it's posted October.
Good! You did it. You did it. You're so good.
I don't know what video.
Subject to laying the proper foundation, I have no objection.
Foundation's hard for her.
But part of the reason I let N and O, I'm letting N and O in, is the fact that it does appear to be the same outfit, and it is two separate accounts depicting the same event. I don't know what the probabilities are that at an older metal market, the same outfit is being, I don't know what that is, but we're going to see what the testimony is, because just because something is posted on the 28th doesn't mean it happened on the 28th. I mean, just last night I posted the video of my daughter hiking the Camino del Santiago from a month ago. And good job, Emily.
No, you didn't.
That doesn't mean she did it yesterday.
And
So, I mean, this
You
is
lied
different.
there,
This is not the
guys.
same outfit. This is not metal market. You can ask your question, and if you can lay the foundation, I'll find it relevant and admit it. Otherwise, I think this one is differently situated, and all we know is that it was posted on October 28th.
She was stomping her feet. She is not claiming her foot cannot bear weight. The doctor suggested after the surgeries that she should not put weight on it. You have to heal first. This is a year after the surgery. So she has been walking around for a year in her boot. She has been living her life for a year. Just takes longer than that to heal. But she's still using her leg. So the prosecution is the one that's saying you're not allowed to bear weight on this foot at all. No one who breaks a foot can lay in bed for a year. Right, Nan? So, yeah, she still uses her... She is still walking while she is healing. And my niece does the same thing. I mean, you have to work and teach your dog to smile.
right.
Any other videos?
Yes.
And actually, since we're on the record, I do not have social media. My wife posted.
Uh-huh, you lied. You just lied there.
Let's get them all up. Let's
This is
not water torture this. This is the last one. All right, your 10:30 video, the smiling dog, which I think I can rule that no dog, when it smiles, looks like it's smiling. It looks like they look like they snarl. But anyhow, what that you're going to mark that as what? P?
He lied.
I as in Isaac.
Why are we jumping around like this?
She is
All right,
trying.
so the
She is trying his nerves to the end. And she's not done trying his nerves.
smiling dog is I. And what video? This is going to be marked as what?
This is J.
All right. And this is a video, I presume, posted on what date?
This is from the Billie Eilish concert. It was posted, which occurred in Denver, November 19th and November 20th of 2024. It was posted
I've heard of her.
This
I'll
is
have to
gonna
play it to remember.
this is gonna
All right,
hurt my
so
heart
the
to mute.
concert, if it's video of the concert, presumably it's November 19th or 20th
Yes.
of
It
24.
was posted in November of 24. She was on strict non-weight bearing protocol post surgery for revision.
I don't think that's in evidence.
Her revision surgery, it's in evidence through Dr. Molcan's testimony.
She testified the date of the surgery.
You want to look at your notes real quick? I have Mr. Black looking at his notes, but I'm fairly confident.
All right, anything else? And what's this video?
I'll describe it and then I'll play it. It is Miss.
Well, then let's just jump to it. Hold on a second. If this is post-surgery, which you were saying is a fact that has been established, and she's walking post-surgery, what relevance does that have to this case?
She was on strict non-weight bearing protocol. It goes to her credibility in terms of whether she was compliant with her doctor's orders. Dr. Molcan says she wasn't. She's giving the opportunity to say she's not, but she's saying that she is. Additionally, I think it's relevant as to the pain that she described. If she is weight bearing when she's not supposed to be immediately after surgery.
I'm not 100% sure, but I'm 80% sure. After we get this verdict, something happens that is crazy. After we get the verdict and the jury leaves, it won't happen today. Then it gets infuriating.
Well, when are you saying surgery was?
November 1st.
But
And that was,
so 3 weeks later.
yes.
She's weight bearing.
I
Your argument is 3 weeks later. This is I can see.
Oh, I'm sorry.
I can see
Interrupt
your
much?
point. I think she has testified that she complied with doctor's orders and was not weight bearing when she was not supposed to, and was weight bearing limited when she was allowed to.
And I apologize.
No.
Dr. Molcan also stated that Constance
Interrupt
self-reported being
much?
non-weight bearing from the revision surgery through December 9th when she saw her for follow-up.
Which is all irrelevant anyhow.
It goes to credibility. She's telling her doctor that she's non-weight bearing and she's going to concerts.
Well, her credibility to her doctor outside of this is not for the jury. Her credibility of her testimony to this jury is what gets impeached. Are you ready?
Yes.
I muted it, so now we can just listen to my son scream in the background instead of listening to Billie Eilish, whom I love forever and ever. BFFs. Maybe I should text her now. Hey, Billie, I had to mute your song today. So, I don't know if you can hear him, but when kids play, when they game, they speak a completely different language. He stopped now, of course. Of course he stopped talking now that I said that. I'm taking him out back. Come on, press play, woman. It's not that frickin' hard. Jeez. Something's happening on the there we go. I muted it so I can't hear, so I will unmute it when the screen goes away. Well, no, let's just unmute it real quick and check.
Concert, not a
I don't relate to you, no.
Yep, I missed it. But it wasn't the song. It was just her singing a couple notes. I think I'm fine. But I'm not unmuted until that screen stops completely. I should have just let it all play. And whatever. Alright, I think it's over. Here we go.
Article.
Billie Eilish, how do we know that that's the Billie Eilish concert from November 23rd, 2020, or November 19th or 20th, 2024?
What I know is that Billie Eilish was touring with her Hit Me Soft and Hard World Tour. She hit Denver on November 19th and November 20th of the 2024 year that she was touring.
Right? I presume the audio is, you can hear it's Billie Eilish.
Yes, I would like to figure that out before. I can also,
Is it a song that only came out on this tour, or is it an older song that could have been from a prior concert?
I believe.
All right, we're going to nip this in the bud.
Okay. And
That she may
believe-
have lied to her, even assuming she lied to her doctor about not being weight bearing on November 1st is irrelevant to this trial. O is not being admitted.
Understanding the
Oh,
court's
I'm sorry.
ruling.
That's not O. It's N and O are coming in. J. Sorry about that. This purported Billie Eilish concert from November 19th has no
I thought the Billie Eilish was I. Wasn't it I? Oh, jeez.
relevance to this, the events of this case, which happened over a month earlier, and what she told her, whether or not she told her doctor anything as to what she was doing after November 1st is irrelevant to this case. So J is not coming in. I might come in depending on the foundation.
Ouch, Lazzy. Ay.
Anything else?
No.
Because did I understand correctly? The issue, the doctor testified that a human being would be really hard pressed to break the hardware, but it's not controverted that the hardware was broken.
Just when is what's
Yeah, right.
controverted.
Right. So we know we know indeed it was broken. So
And we believe it's more relevant to the defense argument that it broke over time when we show that she is continuing to not comply with the doctor's strict non-weight bearing orders.
after the date of it breaking is irrelevant even to that.
Well, I would request to be able to at least verbally inquire because I do think it's relevant to her credibility regarding.
Hey, CJ, if you like Judge Eric, and I'm sure you do because he keeps you on your toes, that's for damn sure, you have to come to this channel. He's only here. How was that, guys? That was good, wasn't it?
Regarding her telling the jury that she always follows doctor's orders.
Look, you had the witness on the stand who could have gotten you there, right? You had the daughter. Have you ever seen mom walk without that would have been real easy. But now you're trying to do it with something where there's real question as to when is something posted versus when did it occur. And that's problematic from the foundation. And that's what I'm struggling with. All right, Jay's out, I is in. And yes, I do think that you may inquire as to her following doctor's orders
Okay.
during the relevant time period leading up, not after, leading up
I do shout, work it, work it.
to all of this. Because the reality is now that we're not dealing with second degree assault, we're dealing with an attempted second. The fact that the issue isn't did he.
Why, yes, CJ, this is exclusive to this channel.
cause SBI anymore. The issue is merely doing anything that caused pain. But, all right, we'll give you some latitude in that regard, but it's got to be in the relevant time frame before. Can you finish up by 5?
5:15, 5:20 is definitely
Are you going to have
Likely.
much? Are you going to have much redirect?
No, not too much. I do have to note Detective Olazaba has to leave around 5 to pick up children. So if he could just be allowed to leave in about 10 minutes.
That's fine. I think you dropped that chair down. You're looking really short. All right, let's get the jury.
I do love this judge. His little remarks. This is the last witness. So
You
once
use a document camera.
she's done,
Yes.
we're done. I saw it, so I already know.
All right, we are back in the presence of our.
First thing this female prosecutor does is tick off the judge when she gets back on stand.
Jury, while we're getting everyone can be seated, while we're getting the witness back on the stand, we go to 5:15-ish. I think we can at least finish the cross-examination of this witness. Is that okay with everybody? Sorry about that. Thank you. All right, let's get the witness back in.
Denver.
All right, ma'am, come on down. And you can retake the stand. All right, and once again, ma'am, I do remind you that you remain under oath.
Yes, sir.
All right, based on conversations and argument that had outside the presence of the jury, I'm admitting N, I am admitting O.
permission to publish N and O.
You may.
So I can't put the live stream for 1 o'clock up yet today because I only get 3 notifications a day with YouTube, and I'm doing a live stream. That takes away a notification. I can't turn that off. I'm doing OJ live stream. That takes away a notification. I can't turn it off. Live streams always give a notification. So I want to keep my last one if I put a video out before 1 o'clock. I want that notification for that. Then I can set up my 1 o'clock live stream. What are the chances of me putting a video out? Probably 0, but just in case, you never know. That's why it's not set up yet. I don't want to burn a notification. Yeah, my eye, I was trying to turn my head. Listen, it's been months and months and months since my eye has bothered me. So, thank you, Canada. I mean, I still have the same problem. Canada just helped. And now it won't again for a while. It just happens. Fozzie hit me.
So Ms. Crowell, this is the picture that was posted directly from your social media.
Yeah.
And you stated previously there was a metal market on this day, but this was an old photo.
Yeah.
I'm
The
showing for the record.
The photo was the video. This is the photo.
I'm showing for the record.
No, you only watch OJ if you're interested in watching OJ. Yesterday was amazing, though. Oh my God, it was so good.
Defense. Oh. Let's just bear with me. I'm sorry if I make anybody dizzy. Ms. Crowell, this is you in the plaid.
Mm-hmm.
You're wearing this same black tennis shoes and fishnets that can be seen in the video that you posted.
Yeah.
And this was not posted by you. This was posted by the Metal Maidens account of the metal market.
You don't have to get on Twitch either. You don't. Twitch is there if you watch the live stream and you get hit with ads because you don't have YouTube Premium, if you have an Amazon Prime account, you get one free subscription to a Twitch channel a month, and you have to redo it every month. But you can use that one free subscription you get to my Twitch channel, and then you don't have to watch ads while you watch my live stream. It's the same. The chat will show up the same, so you'll be able to talk to everybody in this chat box. It's just to help you if you don't want to see ads. That's it.
At Black Hawk Brewery.
Black Sky.
Excuse me.
Yes.
Thank you. Black Sky Brewery. And even though they posted this photo on October 29th, 2024, and your testimony is that there was a metal market on October 28th, 2024, this too is a different metal market.
So all of the footage that was posted here was from a different metal market. We have to do it, otherwise we would be posting the videos and the pictures of us doing it that day, and that's not doable while running a flea market.
But this one in particular was not posted on October 28th when you said the metal market was. This is posted October 29th,
I'm-
2024.
So what is your question?
Was this photo posted by Metal Markets on October 29th, 2024, the date after there was an, as you say, unrelated
She's prosecutor.
metal market?
Prosecution.
Yes.
Okay. Through your TikTok account, you posted a video from Dr. Mulcan's office. Is that right?
Yes.
One moment. That video was posted the day before your surgery, or a few days before your surgery.
I would have to see the dates.
I'm sorry, are we referring to I?
Nope, not at this time. In the video, you say that you are in your surgeon's parking lot the day before your surgery. You don't want to go in.
Objection to hearsay.
Overruled.
That's not hearsay. She's
You
sitting
can
right
answer.
there.
Oh, what was the question?
In the video that you posted on social media, you say that you are parked outside of your surgeon's office the day before your surgery. You don't want to go in.
Right.
The day before your surgery would be October 31st,
Yes.
2024.
Right.
And would you recognize a copy of that video if I showed it to you?
Yeah, I know exactly what you're talking about.
That's the defense. Well, no, that's his defense.
Counsel,
lawyer.
I asked if we had any other videos. Is this something that we've talked about when we were on our break, or is this something else?
This is something else that was in discovery. So Mr. DeCecco has seen it.
I asked you
I
for
understand.
any other videos. All right, let's go.
He's way madder than you think.
Approaching with what will be, if admitted, defense P.
Okay, the guy on the right is the
Counsel
plaintiff.
approach.
Is the guy who is in trouble. The guy approaching right now is his lawyer.
All right, we're gonna nip this in the bud. He is
She
a
just
video
got
of
in
an
trouble.
irrelevant date after anything. That's
He asked her if she had any more videos. She said no, and she just got in trouble.
alleged to have occurred in this case. He will not be admitted.
She's batting zero. I know how you feel, honey. I do. Thank you, JK.
And
Words
then
are
just
hard for
one
me.
moment, and I will be approaching what's been marked as identification as defense I.
It is a complicated question, Kit Kat.
Ms. Crowell, I'm going to play this video and then ask you some questions.
I
Is
don't
this
like. Never
first of all,
mind.
what is this video?
So this is a video of a dog that I rescued. And that rescue was before everything that happened. But again,
Before we get into that, I just want to ask you some questions. What was the date that video was posted?
after the incident, because I had nothing else to post, which we
The
already
vi-
went over in the video.
The question was, what is the date? Do you know the
I
actual
don't
date?
know the date.
I will reapproach.
Sorry, this is foundational counsel. Go ahead.
The date of this video was October 30th,
No.
2024?
That is not the date of the video. There's no testimony to that.
I'm sorry. The date of
Would
the
it refresh your
post.
recollection if it was, would you argue if the date on there shows it was posted October 30th, 2024?
Let me
that right?
refresh your recollections. October 30th, 2024. But I want it to come from. Ms.
Would
Crowell,
you agree that's the date it was posted? Or do you need to see it again?
I will just agree. Yeah.
No, let's go ahead and show it to her.
Okay.
I don't know, Anna Banana. I don't know how we're doing. I don't know. I feel in fear. I feel Judge is going to snap.
Yes, I do.
would you agree that the date this video was posted was October 30th, 2024?
Absolutely.
When did you rescue the dog in the video?
Geez, before Kiefer and I even got together?
But you did own that dog on October 30th, 2024.
No, I rescued it. I own it now.
And that, what does that video depict?
It depicts me
Well,
with
let's lay our foundation before we're going to start talking about that.
That video is from your personal Instagram account.
Yes.
And that video depicts you.
We're not talking about what it depicts. We're trying to lay foundation of when the video was taken.
Judge, I don't even know what to say. This attorney, I don't know what to say. She's going to die if she doesn't watch it. And I did just find out during this trial alone that I could never date a man named Kiefer. Because every time I hear his name, I would be thinking about another man. And there's nothing I can do about it. I don't try to do it.
So I understand that you stated that video was taken before the incident.
Before we were even together.
How do you know that?
Because I was there. I was single. That's how I was able to travel.
And that video was not taken inside of your home? You were traveling?
Yes.
Can you clarify when you were traveling?
Oh. I mean, like, I don't even know. I don't.
But
it's
you're
like-
saying this video was taken when you were traveling.
No, the video wasn't taken when I was traveling. The video was taken shortly when the dog needed someone to watch it. So this was after the entire visit out there even. And the video was I'm trying.
At this time, the defense would not move to admit. We don't believe that the proper foundation about the date has been laid. I guess let me back up, Judge. I'm sorry. I just have
Lazzy,
a few more
thank you so
foundational
much.
questions I may be
Thank
able
you.
to ask
I
at this time.
appreciate it.
Okay.
Thank you.
That dog lived with you at your apartment.
No, it was a foster. It stayed with me because I didn't want it to go back to a shelter.
So that
I-
video that you watched was not your apartment.
Did you hear what I said?
All right, please just
So-
answer the question.
Yes, yes,
Yes, it was your apartment.
yes.
Okay.
But me rescuing the dogs video wasn't.
I understand what you're saying now. We're talking about two different videos. So the video I showed you, Defense I, was taken at your apartment,
Yes,
was posted on October 30th, 2024.
it was posted later than when I had taken it. I had taken it when I had watched the dog for like a few days
But you were watching the dog at your own apartment.
because its foster situation fell through and I didn't want to take it in to get put down.
But that dog did still live with you on October 30th, 2024.
No. Can we slow down here?
Thank you, Lazzy.
Well, if
Thank
that's
you.
the answer, I think we need to move on.
Okay.
So my last question for you, Ms. Crowell, is that you stated on direct examination that you had definitively broken up with Mr. Byer.
Hold on. Stop. She said if that's the answer, I think we need to move on. But did she ever get an answer? I don't think she ever answered the question. Couldn't you just let her answer the question?
Weeks before October 7th, 2024.
He won't let you break up with him. I tried to definitively break up with him.
Objection, non-responsive.
That's, yes.
Overruled.
Sorry.
So was it your testimony on direct examination that you definitively broke up with him weeks prior to October 7th, 2024?
Yeah.
Okay. And I know it's been a long day. At the very beginning of your cross-examination, you listened to a video of you and Mr. Byer arguing, and you agreed that video was taken the night of October 7th, 2024.
I don't know. I believe it was the morning. Wasn't it the morning?
You are right. I apologize. The early morning hours of October 7th, 2024.
I believe so.
Okay. At this time, we would move to publish the statement from that video that is in direct contradiction. And we would be admitting a inconsistent statement at this time.
I'm so confused.
Is this
It's not the whole video.
how much? Like literally the statement? All right.
You get the audio?
You need just the defense table?
Yes, thank you, Kelly. Yes.
Are you going to talk?
I also can't hear
I don't have any
anything right
input
now.
yet.
There we go.
Are you going to talk to her tomorrow?
I forgive and listen to it.
If you give a shit about our relationship, you're gonna fucking answer.
Honestly,
What we just heard was, if you give a shit about our fucking relationship, you're going to answer.
Yeah, I still loved him.
But you had testified that you had definitively broken up with him weeks prior.
Right.
No further questions.
How long's redirect?
5 to 10 minutes.
Are we okay? Everybody? All right. Let's see if we can finish this. Go ahead.
So, Ms. Crow, I just have a few follow-up questions. Do you want to grab your computer? When did you try to break up with Mr. Byer?
Over the course of 2 months.
But on the date of the assault, was he still spending time at your apartment?
He wouldn't leave. I even had to, yeah, he wouldn't leave. Sorry.
What was your understanding of Dr. Molchan's instructions on weight bearing on your right foot in the months before the assault?
Just use my bone stimulator. If it hurts, put your boot on.
Did she ever tell you you weren't supposed to be walking on your foot?
No.
Did she ever tell you weren't supposed to be hiking
Thank
on
you,
your
Kelly.
foot?
Thank you.
No,
Thank
she
you.
said
Thank
do
you.
what activities are comfortable. And the hike wasn't even, it was rampart. So it's not an incline. It's literally just a walk, really.
After the assault on October 7th, did you stop working?
I I was fired.
Um, did you end up going to the concert on October 9th that you were asked about?
Yeah, I had to work.
Okay. And was that like another source of income for you?
Yeah, so at the time I had 2 jobs. I was a preschool teacher and also content creator.
How was your foot feeling on October 9th when you went to that concert?
I was in a lot of pain, but I had to go. I didn't have a choice.
And were you wearing a boot at that time?
I was, yeah. You might even be able to see it in the video when I'm sitting in the chair spinning.
Um, and when you spoke to Detective Olazaba a few days later, was your foot feeling better, worse, the same?
Worse. I had been told that I could still walk on it for what I could bear. It kind of, they let you walk before your surgery, but it's
Um,
painful.
And the photo you were shown in defense, you and a few other women
Mhm.
at the metal market. Do you know or remember when that picture was taken?
I don't have exact dates because
Let me ask a
it was a
different
month
question.
before. It's always like the end of the month or the beginning.
Okay.
So it could be a
So was it
month.
around September of 2024?
Probably before that. It was still warm out, like really warm.
Okay, so around summer of 2024.
Yeah.
Since your foot was first injured way back in 2018, has that been about 6 to 7 years ago?
Yeah.
Have you grown accustomed to walking on that foot even when it's been injured?
You kind of don't have a choice.
When my niece got her boot on, after she had surgery and got the hardware in, the boot, she was still a server. She still had to come into work and serve. I mean, I took care of as much as I could, and then she kind of took care of the bar. But I kept hitting her boot. She kept hitting her boot on everything. The boot made it was like a magnet. I don't even know how to describe it.
Pre-kids.
You were asked about your conversation with Mary Jane about her leaving the apartment. Why were you concerned about her leaving the home unsupervised while she was in your care?
It was late and we lived on West Colfax, 14th to be exact. And I don't know if you've been down there, but it's dangerous for a woman who's fully clothed.
What did you believe your responsibilities were as a person supervising her?
To be the
Objection relevance.
Can you repeat your answer?
To be the parent.
Okay. And defense asked you regarding your interactions with the police on that morning. You were asked that you didn't tell them the details of the assault. Is that accurate?
Yeah.
Mandy, I agree. I this woman, it makes it hard to be on her side. It does, but it doesn't mean she's lying about everything just because she's lying.
When the first officer arrived, Officer Fink arrived, did you tell him that your head really hurt?
I'm pretty sure I did.
Um, and did you tell him that he most likely re-injured your foot, which was already broken?
I mean, it wasn't broken. There was a slight separation between the bones, hence the bone growth stimulator. So it wasn't broken. The hardware was perfect, but
Um, did you tell the officer that he, being Mr. Byer, most likely re-injured it?
yeah,
And you told the officer that, quote, you don't have to tackle me ever, end quote.
yeah,
And when the second officer arrived, do you remember talking to him in that elevator lobby?
I do.
And do you remember telling that second officer that Mr. Byer tackled you?
Yes.
Okay, no further questions.
Okay, I'm wrong. No, I'm not wrong. I just am very, 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 very confused right now. Who the hell was that guy that just asked her questions? Because didn't it kind of sound like he was on her side? Right, he wasn't trying to tear her down. So is this lady over here? This lady over here is his lawyer. Is his lawyer? This guy must be the prosecution. I had it absolutely backwards, right? Because he's trying to help her. So he has to be the prosecutor, right? Sorry. Yeah, she's a liar. I gotta press play. There it is.
All right, any questions for this witness from the jury? Thank you very much. You may step down. You're free to go.
Thank you.
All right, ladies and gentlemen, thank you for giving us 14 minutes of your time. You do not have all the facts. You do not have the law. Don't discuss the case amongst yourselves at all. Don't discuss it with anyone else. Forget about tonight. Relax. We'll come back in tomorrow morning at for an 8:30 start. See, what day is tomorrow? Thursday?
Yeah, I did, didn't I? That's what I said. Okay, now just give me a second. I'm trying to add another media source because if I put it on at the beginning, it wasn't working right. So I figured it was fine if I do it right now and there. And okay, I'm gonna make it bigger. I'm gonna get rid of this one, and I will figure this out better tomorrow for tomorrow's stream. Okay, now we're set up. Now we have to get to the good parts. We have to get to the closing arguments.
Service everything from when you got your summons, the system, everything.
I can't hear anything, but you guys can.
See if there's
Hold on.
anything we can approve or, what your experience was so I can provide feedback to her. So for one last time, I'm going to ask if you go back into the jury deliberation room. I'll only be out here like 2 minutes and then I'll be in. And at that time, like I told you during voir dire, any questions or anything?
Holy guacamole, Batman. 14 months? Wow. Lisi, thank you so much. Oh my goodness.
Else, and I can answer them for you. All right, all rise for the jury. Jury is released to the jury deliberation room. All right, everyone may be seated. Judgments of the jury will be entered. 24 CR 6170 is
crazy.
dismissed. All bonds are released, and if there's no other hold,
Oh no, I just made a huge mistake. Maybe no one will notice. Maybe no one was listening to that part. It is playing. I'm going to try to bump it up a minute. There we go.
all right, so juror number 12. I see you've got the manila envelope, so I presume then that you are the foreperson. All right, and the jury has reached verdicts. All right, if you would hand those in. To Andrew is fine. Thank you.
This is absolutely not closing arguments. This is the verdict. This is the verdict. Unfreaking believable. Hold on, hold on, hold on. Okay. Watch. I need a 3-minute. This is, I'm going to play a 3-minute video while I go get the verdict. I mean, not the verdict, the closing arguments. I got the wrong thing ready. Something y'all missed, but you're gonna like. What's his
Now,
dog's name?
hypothetically, Dr. Cotton,
Wait, pause.
if all the people on that list,
Nope.
Be right back. Dumbass.
Dr. Cotton, at any time in the last 5 months, have you seen a letter? I'm not saying the content of it, Your Honor.
Objection irrelevant. 721. Sustained.
Dumbass. I can't handle this. I can't. Not after the last lawyer in the last live stream. I can't handle this. I'm not built for it. I'm gonna have to go watch Shirley Temple or something.
Dr. Cotton, at least as to the people whose names you recognized, you agree that they have articulated that there exists a
Objection,
controversy.
Your Honor. Hearsay.
Sustained.
Could we approach sidebar? No. Sustained.
Taser.
I ask that this be marked next in order.
Get your taser ready.
Show it to the witness.
Come on.
What?
A letter.
All right. Next in order. Oh, just hand
It's
it.
just done.
Yes.
No, I have murder in my heart right now.
Is this a letter in Science magazine?
No?
What is it?
No.
May we approach it, please, Your Honor? No. All right. What is it? Just tell me what it is.
It is, okay.
Mr. Neufeld?
May I have an
Hold
exhibit?
it like
I'd like
this.
to look at it first.
Hold it like this.
Apparently a
Your
letter.
Honor, there's, Alex, you want to speak?
Counsel. What is it?
It is a letter written to nature signed by
Thank you.
25 scientists.
Thank you. Your Honor, that was rejected and never published.
Your Honor, it was rejected because
Oh,
it's unpublished. That was,
They asked for a sidebar. That's your fault, Ito.
Both of you.
That's your fault.
Dr. Cotton, you can sit down. All right, the court's clear orders regarding objections were no speaking objections. Both counselors sanctioned $250. Get your checkbooks out.
Sanctions! We got sanctions! Oh my god! He pulled out his wallet. $50 ready? You better make it 500, sir. Yes.
The other part was objection. The fact that it was never published was an argument. I'm not going to tolerate that kind of stuff anymore. Are we clear? March over to the clerk, both of you.
March over. He said, you better march. You better march. You're not marching. Sanctions. What's that thing he has? What is that? I don't even know what that is. For all your youngsters out there, it's a
The
checkbook.
attorneys may not bill their clients for this. This is a personal sanction. You're welcome.
OJ's like, I'm not paying him anyway. He might as well bill me. It's not ready yet. It's not ready yet. I'm working on it. Hurry up. Closing. Nope. Yeah, closing. Found it. Download. Download anyway. Alright, I'm going to remove that. Okay. It's almost done. Okay, if you look, his mute button is on. So there is sound. But you see where it says Eric Johnson Eric, it's muted. He has it muted. So we have to wait until he unmutes. We don't have to wait because I have the power of fast forward. But there we go. So everything they're showing right now we can't hear. But any second now he's going to unmute that. Any second now, he's going to unmute that because we just saw. Come on, Judge.
At that point.
Good enough. And again, I
and she
was
wa-
wrong. Again, I was wrong. There's another witness. But he's really short. He's so short, I forgot about him.
Was able to bear weight on her foot, right?
Yes, she was.
But she did express concerns about him re-injuring her foot. Is that fair?
I don't recall that.
Would it refresh your memory to look at your statement?
Yes.
Okay. Hearsay.
801D1B.
Did reviewing that refresh your memory?
It did not. It is not included in my statement.
Okay. Would it refresh your memory to listen to a small portion of your body-worn camera from that evening?
Yes, sir.
Just one moment.
She looks like, from my angle, 12. Actually, the 12-year-old, or however old she was, we had on the stand, looks older than this officer. Yeah, the gold man couldn't handle it anymore. Left. I need one of those chairs, an American flag, to do this job. I don't know what I was thinking before. I need a robe.
Well, I'm sorry, technology hates me today. Would it refresh your memory to review just a transcript of that part of the recording?
Yes, sir.
That would have been quicker to do from the beginning. These lawyers, I'm telling you, these lawyers. I hope I never get arrested in Denver.
Did reviewing that refresh your memory?
Yes, sir.
To rephrase the question, did Ms. Crowell express concern that he had likely re-injured her foot?
Yes.
Okay. That said, there's no follow-up about the injuries she expressed.
Correct.
And later on, she was crying about her head hurting.
I don't remember that.
Okay. Would it refresh your memory to see that part of the body worn?
Yes.
And if you couldn't play the last video, what makes you think this is a good idea right now, sir? Okay, I just struggled playing videos, so you know what? I'm gonna let him slide. No, I'm not.
Did reviewing that refresh your memory?
Yes, sir.
Okay. She expressed loudly, or she expressed that her head was killing her at that time.
Correct.
But Officer Fink didn't clarify why her head was killing her.
He did not.
Okay. And in order to make an arrest, you need to get a detailed account of any kind of crime that may have occurred, right?
Correct.
Now, later on, Fink indicated that he couldn't make anyone leave the apartment,
Yes.
and he told the party essentially to ignore each other.
Correct.
And she, sorry, one moment. And she had expressed that she had a bruise on her head, right?
Correct.
And no follow-up was done about how she got that bruise.
Correct.
At a later point, you're speaking to Mr. Byer outside again, right?
Yes.
And there's a discussion about what keys he may or may not have.
That is correct.
And he claimed he had a key, but he wasn't sure which one it was.
Yes.
Okay. But eventually, you were able to determine a key that went to the apartment, right? And later on, when you're speaking with Ms. Crowell, she indicated that she didn't feel safe at that time,
Correct.
and she was in tears.
Yes.
She was concerned with what would happen if something were to happen again.
Yes.
Okay. And Officer Fink didn't really address that concern of hers.
He did not.
And she expressed that she, again, was trying not to get hurt again. Is that fair?
Yes.
And then Officer Fink and you walk out of the apartment.
Yes.
Later on, Officer Fink is speaking to Mr. Byer and acknowledges what Ms. Crowell had said about the tackling, right?
Correct.
And that and he indicates that he never touched her, right?
Correct.
And his daughter was overhearing this whole conversation.
Yes.
And Mr. Byer indicated he had video evidence of this.
Correct.
Okay, he didn't show it to any of you.
No,
Neither of you asked to see the any videos he may have.
we did not.
Okay, just one moment. Thank you. No further questions.
Hey, redirect.
Just briefly, did you observe any injuries on Miss Crowell?
I did not.
Did she try to show you her arm?
I think in the video she put her arm up like this, and I did not observe anything at that time.
Okay. And did you give Miss Crowell the opportunity to leave?
Leave the apartment?
Yeah.
Yeah.
Okay. Did you complete a street check in this case?
Officer Fink did.
Okay. And what is a street check?
It's a documentation that we create if we don't have enough to make an arrest. Officers document in a street check, which is an internal documentation for us to pull up if we have to run these parties or the address related to it.
Okay. And is a street check the last step in your investigation?
Yes,
Okay. And was there anything criminal for you to resolve?
there is not.
No further questions.
All right, any questions for this witness? Seeing none, thank you very much. You may step down. Appreciate your testimony.
It was very memorable.
Defense next witness.
Defense would rest.
Is there a rebuttal case from the prosecution?
There is no rebuttal case.
Parties approach.
Parties approach, but I didn't cut this out, Judge. This is not okay.
You've got two options here. You can either just keep these things closed and listen to me as I read through them, or if you want to follow along, you may follow along. I just ask that you don't go ahead, lag behind. You'll have all the time you need to examine or do whatever else you want.
If you don't mind, I will put this video as it is, uncut, up on my Patreon. And if you don't know where my Patreon is, just look at my channel on YouTube. The Patreon link is in the description. And it's also in Discord. And you can hear the judge reading the jury instructions there. But I'm going to fast forward them because I don't want to listen to them again and again and again. They're very boring. And we're going to go to the closing statements. So he reads the jury instructions and then they close. All right, hold on, slow down. It's very difficult to fast forward here, so this is where I'm staying.
Gets to do a rebuttal close with whatever remaining time they have available. On behalf of the prosecution, do you want the lectern?
No, that's okay. Could I get prosecution table?
It's free to watch on my Patreon. It doesn't cost any money. Just forgot to say that.
Throughout this trial, you have heard a lot of witnesses, and you've heard a lot of things said about what happened this morning on October 7th, 2024. The evidence shows that there was an assault, that the defendant, Mr. Byer, tackled and pushed Ms. Constance Crowell, causing her to hit her head and land on the floor. He slammed her head on the floor, causing her to hit her forehead multiple times, resulting in a bruise and an immense pain, and that he took her foot, twisted it, squeezed it before twisting it, and she felt it pop. Now, these are the two charges you're being asked to consider today. The criminal attempt to commit assault in the second degree, serious bodily injury for the attempted assault on her foot, and then the completed a third degree assault for the injuries to her head. And the burden, you are required to hold the prosecution to is proof beyond a reasonable doubt. And this is a burden we do not take lightly. It is a burden we ask you to hold us to. It is a burden that requires more than proof that something is highly probable, but does not require proof with absolute certainty. You may have heard the phrase, proof beyond a shadow of a doubt. Well, that is not a legal term. It is proof beyond a reasonable doubt. It's proof that leaves you firmly convinced of the defendant, Mr. Byer's guilt. And if you are firmly convinced of his guilt, then the prosecution has proven the crime beyond the reasonable doubt. But if you think there is a real possibility that he is not guilty, we have failed to prove the crime and you should find a verdict of not guilty. So I want to go through the timeline of events here. Well, we'll even start before that. The night before, Ms. Crowell was there with her 3 kids and Mary Jane Byer. Mary Jane left to go to Walmart at some point in that evening. There was some discussion around that. Around 3 a.m., Mr. Byer returns home. According to Ms. Crowell, she heard him and he woke her up. She said that he wanted to see her vagina. And there was an argument that ensued, argument about his daughter, and some concerns that she had. And there's an argument. And at some point during this argument, the altercation goes from a verbal one into a physical one. And they go from the bedroom into the hallway. And you got to see video of that very small hallway. And you have a diagram of it as well that Ms. Byer drew. And you can see that it's fairly small. This is when Ms. Crowell says, he tackled me. My head hit the door frame and the wall. And that when she was on the ground face down, he slammed her head into the ground and then pushed off of it. And again, when he squeezed and twisted her foot. This was the last straw for her. She was scared. She wanted them to leave. She was worried for her children. And this is also the point in which Mary Jane and Lily come out of the kids' bedroom and see her on the floor. They walk out to the patio. She's scared. She locks the door. Eventually, she lets them back in. She calls her parents. They call police. He also calls police.
Lazi, the very best, absolute best way you can support this channel, the very best, absolute way is free. I post some videos every day. They're usually short, 10 minutes. Just watch it the whole way through to the end. That is the very absolute best thing you can do with this channel. Watch the video the whole way to the end. Thank you. Thank you.
Police respond the first time. They speak to Mr. Byer and Miss Byer outside. Then they go up and speak to Miss Crowell. And we'll talk a little more about that later. But to them, this became more about her wanting them to leave. She was scared. She wanted them out. She wasn't asking them to arrest him. She was telling them that she was injured, but her main concern was getting them out. And the officer said their hands were tied, they couldn't do anything. The buyers come back in the apartment. They weren't in separate rooms like she wanted. She was still scared. Police were called again. And you heard from Officer Nicholas, who was part of that second response. And when he arrived, he assumed the prior officers had done all their investigation and that he didn't have to do anything regarding the injuries or anything she alleged. Ultimately, over many discussions, it was decided probably best for them to leave. Later that morning, Ms. Crowell drops her kids off at school. She goes to Denver Health. She's in pain for her head and her foot. She discloses these details to Dr. Trent, as you heard. There's some concerns about a concussion, some fuzziness, the pain in her head. The first x-rays were taken of her foot. She doesn't make a report at this time. The same day, Mr. Byer goes and gets a protection order against Ms. Crowell. And you heard testimony that later that night, police or officers show up at the apartment, have Ms. Crowell leave because of the protection order. And the Byers go back in. That next morning, Ms. Crowell goes into her foot doctor specialist, has more x-rays taken, learns that she's going to have to need surgery for the broken hardware. And then she decides to visit the Rosanum Center and makes a full report of what happened. Learned a warrant was issued for the arrest, and then later both of the kids were interviewed. So let's talk about the elements of each of these crimes. For the attempted second-degree assault, we have to prove Mr. Byer, state of Colorado, date or place charged, knowingly engaged in conduct constituting a substantial step toward the commission of assault in second degree. What is a substantial step? It is any conduct, an act, omission, possession that is corroborative of that person's purpose to complete that offense. And so you, to find him guilty, should find that he engaged in the conduct, number 4, constituting a substantial step towards the commission of this crime. That he...
Objection, may we approach?
Overruled.
Yeah.
Argument.
Gunnar, they misstated the law.
They've been instructed on the law. They've been instructed the attorneys may comment on the law. This is argument. Overruled.
These are the elements of assault in the second degree. In the state of Colorado, at or about the date and place charged, with intent to cause bodily injury to another person, cause serious bodily injury to the person or another person. And this is how serious bodily injury is defined. I'm not going to read this whole thing, but the key part is breaks or fractures. Those constitute serious bodily injury. Now, we are not getting up in front of you and saying that he caused serious bodily injury, that he caused that break or fracture, because you heard Dr. Mulchan testify that she can't say that he caused that fracture. She had a long history of injuries and surgeries to that foot, and she was doing okay. She was weight bearing, she was walking on it, she was doing pretty fine, but you heard testimony that there was non-union, meaning the bones were not fused together. She was using a bone stimulator. The no-brainers with this charge, you all know the defendant, Mr. Byer. He was identified in court. You all know where this occurred. It happened in Denver, happened in Colorado. And we know the date, heard it many times, October 7th. The key part is knowingly, and you have to find that he knowingly engaged in that substantial step.
Objection, misstatement of the law.
Overruled.
That he knew about her repeatedly broken foot, and that he knew that she was using that bone stimulator. He knew about her foot and knew how vulnerable it was. And that knowing this, he engaged in the substantial step. He tackled her to the floor. He squeezed her foot as hard as he could, and he squeezed the middle of the foot. And these are the x-rays showing the broken hardware in her foot. And you heard her say she felt it pop. There was a change from this assault. You see the screws that are out of the plates. This corroborates what she was telling you. This hardware broke. We can't say affirmatively when this hardware broke. Could it have been before? Yes. But you heard Dr. Mulchin testify that even though she's unable to say how it was broken, that the assault could have forced the timeline of her surgery. Now, what corroborates what Miss Crowell came in and told you, the evidence that she gave you from that stand? You also heard from her daughter, Lily, that she heard the screaming. She heard her screaming, ow, my foot, my foot. That she got up and she saw her mom on the floor. You also heard that she told the officers that he had likely re-injured her foot, which was already broken. Turning to the next charge, third-degree assault. This is for the injury to her head. And these are the elements that Mr. Byer, same thing, state of Colorado, knowingly or recklessly caused bodily injury to another person. And this is how bodily injury is defined: physical pain, illness, or any impairment or physical or mental condition. You heard Dr. Trent testify about what she said again, that she was having a headache. She reported being struck in the head. She was tackled and punched. Her head felt fuzzy. And there was a bruise that the doctor noted, a hematoma on her forehead. And just keep in mind, this is all before she knew that he was going to get a protection order, way before later in the night when that protection order was served. You heard testimony from Lily that, again, she heard this screaming. She heard her say, ow, my foot, and saw her on the floor. You also heard her testify that she was able to later see that bruise when it was like outside in clear daylight. You also heard testimony from Miss Byer. Testified she heard 2 bangs, that she saw Miss Crowell on the floor, and she saw a bump on her head later in that day and actually took a picture of it. Now, she told the officers about her head. She was screaming, and you heard in that video her saying, like, my head is killing me. And on Officer Nicholas's body-worn camera, she's kind of pointing out, describing, and he wasn't able to see an injury. Though I encourage you to look closely at that video, look at her head and see if you can start to see any marks on her head. Now let's talk about the investigation. Officer Fink and Morris show up. You know, they first get Mr. Byer's side of the story while his daughter's there. They didn't take any efforts to separate them, get different accounts. They were just going mostly on what Mr. Byer was saying. Then they go up and speak with Miss Crowell. She's panicking. She's scared. She expresses to them, in part, what happened. But they don't ask any follow-up questions about being tackled or about her bruises or about her head. No, this conversation only becomes about who gets to live in the apartment, who has residency. And yes, she wasn't trying to get him in trouble that day. She just wanted to get them out. She wanted to feel safe and wanted her kids to feel safe. So that was her primary concern. But the officers didn't do any more to look into her injuries to see what actually happened that night. So they left. Then the other officers come back. And by and large, they assumed that the prior officers had done their jobs completely and that they had investigated all the injuries. So they felt that they didn't need to do anything more. But where this case becomes important is when she decides to report and decides to give a full and detailed account, and without the heat of the moment is able to sit down and describe what went down and report it to Detective Olazaba after having previously told not just one, but 2 doctors what had happened. And then there's interviews with the children to get their side of the story about what happened. And then, of course, medical records from those appointments. One of the most important things for you to consider, arguably the well, one of the most important things is credibility. And that is your job as jurors. You are the sole judges of credibility of the witnesses, and you should carefully evaluate all the circumstances of the testimony. And there's a list of factors in those instructions for you, and I just like to point them out. Knowledge. Consider that witness's knowledge, what Ms. Crowell knew about what happened to her, what the children saw. Think about motive and state of mind. Think about their demeanor while testifying. Now, of course, Miss Lily Crowell is Constance's daughter, right? You can take that into consideration, but consider how matter of fact she described things to you in the same way and the same thing she told the interviewer. And also consider Miss Byer, how she is the defendant's daughter. She's been with him this entire time, heard the whole conversation with the officers, and consider her credibility. Consider the witness's ability to observe. The only witness that actually saw and was there for happened was Miss Crowell. The other children, they were in the room. They were able to hear, so they were able to observe with their ears, but they were also able to observe the marks on her head. So were the doctors. Consider the strengths of that person's memory, how they obtain their knowledge, the relationship to the side of the case, how they might be affected by the verdict, and how it's supported or contradicted by other evidence in this case. And the important part is Ms. Crowell's testimony and how it is supported by the other evidence in the case. The x-rays showing the broken hardware, the evidence of the bruise, and what the children remember hearing that night. Now, earlier at this trial, the court talked to you about credibility too, and how credibility is not the same as likability. That's true. You as jurors aren't required to like any of the witnesses you spoke. You don't have to like the officers and what they did or didn't do. You don't have to like Miss Crowell and her parenting decisions and what she said or did or didn't do. This case is not about likability. It's about what is credible. And the credible evidence shows that there was an assault and that Mr. Byer chose to use force against Miss Crowell, and he caused that head injury, and he engaged in a substantial step towards committing a second-degree assault.
Most of you said guilty. That's what most of you said.
Find him guilty on both counts.
All right, on behalf of Mr. Byer, Mr. Black.
Your Honor, first, I want to restate my objection and ask the court to admonish the jury that the
I've
relevant.
overruled the
relevant-
objection. You can make any other record later. Do you have a closing argument?
Yes.
The whole table's going to get sanctions. Sanctions. Get your checkbooks
And
out.
you need defense table?
Not need audio.
I did close the poll, but it's not going away. I don't know why it's not going away.
You keep going with it. All right, Mr. Black. Mr. Black, I need you to pull it this way, and if you're trying to get it closer, you can keep going, but I need you to push this way so that nobody is, there you go.
I'm going to
Now
start a
everyone
new
has clear
poll
views of everyone.
just to clear this one.
Go ahead.
Thank you.
I'm going to close it right away.
Frustration, an accusation, and a solution. Mr. Byer is not guilty of assaulting Ms. Crowell. Mr. Byer is not guilty of attempting to break her leg. Despite what the prosecution just told you, the relevant intent for an attempted assault is not knowingly It is higher than that. It is intentionally. Prosecution just tried to lower their burden. They just told you something that was not true. You have the law in your hands, what you will. And it tells you to prove the crime of attempted assault in the second degree that Mr. Byer in Colorado, with intent, engaged in a conduct constituting a substantial step, not knowingly. It is higher than that. What I want you to think about in this case
Always videos.
is credibility.
Videos are way more important than live streams. Why? Because my live streams are bad. Nothing is going to fix them. Nothing is going to save my live streams number-wise to make them good. They drag everything down. But my videos pull everything back up. So just watching a video to the end, like if you watch a minute of a 9-minute video, that's really bad for me. It's better if you don't even watch the video. But if you watch it to the end, that is the single most helpful thing you can do, because when you watch a video to the end, it tells YouTube, oh, this is a video people would want to watch to the end, and then they show it to more people. And that's the thing. Like they open it up at another bucket of people to show it to. So watching a video to the end is the best way. It's the single best thing you could do.
Just ask yourself, is Ms. Crowell credible? You saw her testify for about 3 hours yesterday. And sure, at first, some of that lengthiness was because of tech issues on both sides. But as the afternoon drug on, Ms. Crowell could not commit to anything. She could not commit to one story. She could not commit to even agreeing that a post was posted within the time that she said it was posted. She could not agree of things that were just obviously true. And I want you to consider that. She's claiming a twist injury to her foot. Now, you heard from Dr. Mulchan that Ms. Crowell has a long and complicated history of injury to her foot. It started in 2018 when she got in a car accident. She didn't get surgery until 2019. And in 2019, she was instructed by her podiatrist not to put weight on that foot. And she's been continuously instructed not to put weight on that foot since 2019. Now, Dr. Mulchan did tell you around July 2024, we told her she can put some weight on the foot, but she needs to wear that boot. Ms. Crowell has never been cleared to fully weight bear. And you watched many instances of her doing that. And you also heard from Dr. Mulchan that she observed that many times, including one time where she told Dr. Mulchan, I haven't been weight bearing, but literally was wearing slippers and no boot at that time. Ms. Crowell is not credible. And this entire case depends on her credibility. This entire case depends on you believing that this happened, these heinous accusations that she made, that she had 10 out of 10 pain, but then you observe her standing fine. This is at 4:48 in the morning, just an hour after she alleges 10 out of 10 pain, a smashed foot, a new broken hardware. It doesn't make sense. Now, you have x-rays that show there is broken hardware, but you also heard from Dr. Mulchan that it is extremely unlikely, if not impossible, for a human hand on one instance to break the hardware she installed. It would take 960 pounds of pressure to do that. She told you it was much more likely that over repeated instances of weight bearing over a substantial amount of time since 2018, she has never followed her doctor's orders. Never fully, at least. And she re-broke her foot. And she's frustrated about that. Dr. Mulchan told you that Ms. Crowell is a fall risk. She falls a lot. She's got multiple instances of car accidents, falls, and she's been repeatedly observed weight bearing, driving without a boot, walking around without a boot, going to concerts without a boot. And then she told you, okay, that was me at the concert, but I was sitting. But you can observe that video for yourself. She was not sitting. And that was 2 days after this alleged offense, after she allegedly re-broke her foot, after this horrible assault, allegedly. You can play. And you can see here, even while the police are responding, she's not taking this seriously. She's still talking to her parents on the phone. Finally, she starts to talk to the officers calmly, collectedly. She doesn't seem like someone who just went through a brutal assault or a re-broken foot.
Lazi, this is what happened yesterday. See, YouTube shows a video to my subscribers first. If they don't click it, just my subs, it won't show it to anyone else. Ever. Ever. No one else gets to see it. So yesterday I released a video. Like, I don't know. I think like 16 subscribers clicked it. So that was it. Video dead. The video never went to anybody else. That's why if you say to a friend, hey, you should subscribe to this channel, we need more subscribers, if that friend isn't someone who likes court videos, it might kill my other videos. So if you do suggest my channel to a friend, just make sure they like court videos, because if they show this title and this thumbnail to someone and they don't click it, then they stop showing it to other people. It's very good at picking out who might like it and showing it to them, but if they don't click it, that's it. It doesn't go any further. And it all starts with my subscribers. You guys are the ones that either say if my video is going to do well or it won't do well. It's interesting. It's fun. It's fun to figure out. I mean, every day I pull apart my videos like crazy trying to figure out what you guys like and don't like. And I loud and clear heard that even if I have a really good clip of OJ that's funny, you guys do not want to see it. All right, back to work. Back to work.
She says the officers didn't take her story seriously, didn't care, but they're sitting here listening. She explains what she says happens, and they determine there's not enough for her to arrest. Officer Fink told you, I didn't see any injuries. She was walking fine, and it seemed like this was a problem that was not a criminal problem. They just needed to separate for the night and figure this out. You heard also from Officer Mares, I didn't see any injury. Did she try to show you an injury? Yes, and she still didn't see it. So you can observe her trying to show these injuries to the officers, and they're paying attention. It's on camera. But they don't observe an injury. They don't believe this story because it isn't credible. You'll have exhibits that show that Miss Crowell continued to bear weight even on October 29th, 2 days before she was supposed to go in for surgery to fix this alleged this broken foot again. And then she told you at the end of the People's Redirect yesterday that her foot wasn't broken at that time and that her hardware was perfect. And Dr. Molchan told you that that was not true. Dr. Molchan cares about her patient, but she still had to tell the truth, and she still told you, this is not what, I cannot determine that this is what happened. Now you are the sole determiner of credibility. For this story to work, for the prosecution's theory to make sense, not only do you have to believe that Ms. Crowell is telling the truth, which I think you can see that she is not. You also have to believe that Lily Crowell was not coached to tell the story in the way she told the story. You heard from forensic interviewer Holly Reinhart that any adult who talks to a child before this interview could taint that interview, could taint the story, and could increase the chances of fabrication. Lily Crowell told you that she saw Mr. Byers standing over Miss Crowell. But then when she was able to see her statements, she sort of walked it back and said, well, that was part of the story. That's part of the story. That's part of the story that mom told her. But it wasn't the truth. And yeah, you can consider that Mary Jane is also Mr. Byers' daughter. You can consider that. But Mary Jane didn't try to guess at anything. And Lily Crowell didn't either. She was only refreshed with her statements, and she just she tried to tell the story how she was told to tell it. Now, when we talk about the actual intent that you need, not knowingly, but intentionally means that your conscious objective is to cause a specific result. That Mr. Byer was attempting to break her foot, whether or not he actually broke it or not. He was I'm misstating it because of the prosecution's misstatement, intentionally engaged in a substantial step towards breaking Miss Crowell's foot. And I think you can find that that's not what happened here. I think you can find that he did not even cause this little bump to her head. I mean, it's not a little bump, it's a goose egg, but you do not have enough to see that Mr. Byer caused that. You know that Miss Crowell falls often, and she's frustrated with Mr. Byer. He won't leave. Why won't he leave? Because he has established residency and his daughter's there. It's the middle of the night, on a cold night in October. Cold morning. And so the officers try to negotiate with both of them, try to come up to a solution. And Miss Crowell, after being told that it wasn't squatters' rights, says, well, why does he have squatters' rights? That's not what we're talking about. Mr. Byer established residency. He was allowed to be there. And the police did not have enough to arrest him. They all told you that. They were in the best position to know that. They were there just 1 hour after this allegedly happened. And then again at 6 a.m. And so when Miss Crowell's story doesn't get an arrest like she wants, later that day, she actually gets served with a restraining order. And now she's really frustrated because she has to leave her home. I mean, she is on the lease, but Mr. Byer is also a resident and he cannot be forced to leave. And so one of them has to leave, and so she has to leave. And that's frustrating. So she goes the next day to Detective Olazaba. And like the prosecution told you in opening, she did that to give a better story. To give a better story that might result in an arrest. Because what she said before just wasn't enough. So she makes up a new allegation about wanting to see genitalia. And when we heard and we know that the argument was about MJ, the argument was about Mr. Byer's daughter going to Walmart without Miss Crowell's permission and buying food because she didn't make her dinner. We know that Miss Crowell is frustrated about that. And you don't hear anything, and you heard from Mary Jane that she heard them talking about her. That's what she heard. It woke her up. It was loud. She heard a bang, 2 bangs, and she could hear them talking about her. They were not talking about anything else. So I think you have plenty to go off of when you're listening.
Sir, what were the 2 bangs? What do you think the 2 bangs were? Drums?
When you're listening for Miss Crowell's credibility. You saw over and over again yesterday Ms. Crowell would deny even that she posted something or that it was a picture, but actually it was a picture from a year ago. It actually doesn't matter that it was a year ago or 2 years ago. She's never been cleared to bear weight. She's never been told by a doctor, it's okay, you can bear weight without at least a boot. And so after 6 years, 5 years of repeatedly bearing weight, repeatedly walking, dancing, jumping, all of these things, hiking, burlesque dancing, she told you she re-injured her foot when she was doing a burlesque dance. She told you that. After all of that, over time, this hardware fails. And we don't have an X-ray from before this allegedly happened, but we have an X-ray from after, and it shows broken hardware. But like Dr. Molchin told you, that's caused because there's space between the plate and the metatarsal bone. And we don't have to get too much to the science of it, but that there's space, and this hardware is not designed to withstand that type of pressure over time. But that one instance of pressure essentially could not cause this and did not cause this. Moments. So you'll go back and you'll have the exhibits and you'll be able to review everything we've talked about. I'd ask you to review this video we just submitted as well through Officer Mares, showing literally right after, for 12 minutes, she's standing after having a 10 out of 10 excruciating pain. It's not credible. The officers didn't find it credible. And you have enough to find that it's not credible.
10 out of 10 excruciating pain was watching your coworker try.
They have the burden of proving beyond a reasonable doubt that Mr. Byer intended to take a substantial step towards a serious bodily injury. And that's not been proven to you. And then the prosecution tried to confuse you with Mary Jane's drawing, because apparently her drawing has to be perfectly to scale, and this, you can see the apartment, you can see how small it is, and you can see that Mary Jane was able to see into her bedroom. She could see that her dad was just getting out of bed while Miss Crowell was already on the ground. She heard 2 bangs, and we don't know what those were, but it could be her hitting her head and falling. Prosecution has not given you any reason to believe that Mr. Byer is the one who caused this. No credible testimony has come out about that. We only hear from Miss Crowell, Miss Constance Crowell, who I think you all can determine is not credible. And we talked a lot in jury selection about the burden of proof, how it's always on the prosecution. It's never on defense to show anything. But we brought evidence. We brought some evidence, and you can consider that. But Mr. Byer has remained silent, and that is his right. He did not have to show videos. He did not have to do anything that the prosecution is trying to infer that would have established his innocence. He has no burden. The burden is with Mr. DeCecco to prove beyond a reasonable doubt. We talked about how high that burden is. Beyond a reasonable doubt is higher than highly probable. Even if you think this is highly probable, he probably did this, that is not enough. Beyond a reasonable doubt, is there a real possibility that this didn't happen? And I think you can find that. There is a real possibility that this did not happen. Mr. Byer is not guilty. So I ask you to go back to that jury room. Remember what you were told by Dr. Molchen. Remember what you were told by the officers. Remember what you were told by even Miss Crowell, because she told you a lot of things that just didn't add up, that didn't make sense. Her hardware was not perfect. Her foot was broken. But when she gets confronted with her own statements, she can't agree that those are her own statements. She then tells you, oh, it must have been doctored. He pulled his own statements out of this. That is me, but it's not the whole thing. She wouldn't agree to anything. She's not credible. And this whole story relies on that she would be credible. So I would ask you to find Mr. Byer not guilty.
Okay, that's it. That's all we have for today. He's gonna get up again, and he's gonna try one more time to persuade the jury, and then we're gonna see that tomorrow, and then we're gonna see the verdict, and then we're gonna see what happens after the verdict. Because this guy's in more trouble than just this. He has other issues. Yeah, he does. All right. I'm very sorry about the technical glitches. And the video not having the wrong video. I'm sorry. I'll be better tomorrow. After this is over tomorrow, we're going to spend 2 days with Judge Manning. I miss Judge Manning so much. We're going to spend 2 days with Judge Manning from a bit ago. This isn't a current case. I just went back and I went to one of her older ones, and I just love her. If you don't know who Judge Manning is, which most of you do, but some of you are new. We were all new at one time. Get ready, because you're going to fall in love with this judge. I'm going to set OJ up. It'll just take me a moment to set OJ up. And then later on today, we're going to do the last part, the very, very last part of Ralph Menzies' fight to not get shot by a firing squad on September 5th. And that's because he took it to the Supreme Court of Utah. So we're going to watch the Supreme Court of Utah at 1 o'clock today. Now, you know how Supreme Courts work. Well, maybe you do, maybe you don't. You don't argue in front of them and then they give you a verdict. You argue in front of them and then they think about it and issue a written order, verdict, opinion later. So we're going to hear their opinion at some point between now and September 5th. So they are either going to stay his execution or they're not. So we'll find out what they say how they argue in a couple hours. Thanks for coming out today, guys. Thank you so much. I'll see you again later. Bye.